I'm Jennifer Moore with Marcellino Moore, and I just got finished speaking with our resident mediator, Deb Dilman. She is a family law attorney in our office, but also a mediator. So we talked all about what mediation is, what it isn't, what to expect out of the mediator, the process, your own lawyer. I think it's a really good podcast. I hope you get a lot out of it. Enjoy. Deb, we are so excited to have you in our firm because you are a mediator, and that's something that nobody else is in our office. So I think it is important for everybody to hear what you do as a mediator and understand the mediation process from the mediator's perspective, something we hadn't had until you joined us. And then also hear from my perspective, the attorney's perspective on the mediation process, and we can just talk through what that looks like for our viewers.
Great, thanks. Well, I'm thrilled to be working for Marcellino Moore. I have been practicing for almost 23 years and started out like you as a litigator, most of the time always litigating, but in my heart, I've been a problem solver. So once I passed that threshold of practicing for 5 years, I was allowed to take the mediation training, and I have been mediating and combining that with a regular practice, trying to stay out of litigation as much as I can, but mediating as much as I can, both as an appointed mediator as well as private selected mediations.
Okay, so let's pause because I want to understand, and I think everybody wants to understand, what does it mean to be the appointed mediator versus somebody selected in a private mediation?
Yeah, great question. So in the state of North Carolina, for all equitable distribution claims, the statute requires that you go to mediation. You can elect a private selected mediator, or you can just go to a hearing and have a mediator appointed. And if the mediator is appointed, that same requirements that you have for the Dispute Resolution Commission, but it's at a different rate, which helps some of the pro se litigants be able to try to resolve their case in mediation versus protracted and expensive litigation.
So let's pause because you just said a bunch of big legal words that I'll explain. So pro se litigant, that means somebody who doesn't have lawyers.
Right.
And oftentimes those are lower income individuals who can't afford a lawyer but still have these issues, that we need to resolve. And so when you say a pro se litigant that goes to a hearing, that means they go to the courthouse, they're told when to be there. They go to the courthouse and the judge says, I am going to require you both to go to mediation to try to work out your differences. And then you're appointed as a mediator in that situation.
Right. Every judge has a list of appointed mediators that have agreed to mediate in this particular jurisdiction.
Okay.
So for me, I won't take appointed cases out of Mecklenburg County, but I do private selected mediations in some of the outlying counties.
Got it.
But yes, so private or appointed mediations, they are determined by statute that you have to go, but the requirements the mediator has to follow, in addition to their own ethical canons, has to comply with the Dispute Resolution Commission of the state of North Carolina. So there's a whole set of requirements that the mediator has to comply with in order to be an appointed mediator in some of these cases.
And those requirements are the same for if you're appointed or if you're chosen by private parties.
As long as the case is in litigation, that's correct. If it's pure voluntary and there's no litigation pending, those rules do not apply. But as a mediator, I typically ask the attorneys in those types of situations whether or not they want to comply with the Dispute Resolution Commission requirements. Just makes it easier.
Sure. Okay, so then talk about what that process looks like for you from start to finish.
Yeah, so for me, it's important for me to tell the litigants that the entire process for me is confidential. I can't blab to anybody about what's discussed in mediation unless somebody brings up something criminal, which in 15 years of doing this has never happened. They're smart enough not to admit that to
Nobody's telling you they have their,
hidden account
in the Grand Cayman
exactly.
Islands. Oh,
Right.
Bummer. That would have been fun.
Well, that would have been fun.
Yeah.
But it's never happened. So for me, it's a completely confidential process. I can't be called to court later if we don't get it resolved to be able to testify about what we discussed. It just doesn't happen. And then, of course, the litigant, if they're represented by an attorney, they have attorney-client privilege. So the attorney also can't talk to anybody about what happens in mediation outside of who's in mediation in their own office. But for the litigants, and this is a difficult one, they are not bound by confidentiality.
Sure.
They can talk to anybody they want to about it, but I always caution them. Even well-intentioned family and friends don't know what's really going on behind
Right.
closed doors. So be careful with that.
Yeah.
But what litigants cannot do is, if we don't get it settled, they cannot tell the court what we discussed. They can't disclose to the court what we discussed in mediation.
Yep.
So for me, it's super important for me to make sure folks understand that, so that they feel free to tell me anything they want. I am allowed to keep secrets as long as they're not criminal activity.
The account in the Caymans.
Exactly.
Can't keep that secret.
But, and people, there are affairs that have happened. Some may know about them, some may not, and they may not want to disclose that. I'm bound. I'll keep that secret. But for the most part, anything that they tell me, I'll try to use to resolve their conflict for them. That's what my role is. My role is not to understand the law at the level the attorney understands it. My role is to mediate, resolve the conflict, problem solve, help people be creative in getting a resolution that works for them, and if there's children involved, works for the family.
Yeah. And I think that's a great segue to what it's like on my end as the attorney, because I utilize the mediator as almost my sounding board sometimes, because you're not required to know the law, but you've been practicing for 20 plus years. And of course, you know the law. And oftentimes when I'm mediating, I look at my mediator who's a friend, who's, a colleague, somebody I know very well. And I can say, Deb, what do you think about this? Because I'm thinking XYZ, because I've got this case that tells me I'm going to win. And I get a little fiery and passionate about it. And I'm like, I just would rather go into that courtroom and win. And, and usually my mediator says, calm down, Jen, and helps us work through whatever we got from the other side in a way that is knowledgeable about the law, but is still neutral and facilitating that resolution.
Yeah, and that's a good point. I mean, there are attorneys that come into mediation just to check the box, to say that they've done it.
Sure.
And so they become very difficult, and they can sometimes get in the way, because I believe that the majority of clients that go to mediation really want to be done with their lawyer. They want to be done with the case. They want to be done with the lawyer. They want to close this chapter, and they want to move on.
Yeah.
So when you have attorneys that aren't willing to listen to their client or listen to the mediator sort of talk about those things, it makes it really difficult to resolve. But I will also say I have mediators like you, or attorneys like you and others, who use me as a second resource to sort of confirm what you've been trying to explain to your client, or not, if if it's not working that way. And so I do tell everybody, I'm not going to give legal advice, even though I have been practicing for a long time. And if you have a great attorney, rely on your attorney for advice. But if your attorney asks me for advice, I'll weigh in on that. And because I have litigated and stay involved with litigation, I understand the local practices here in Mecklenburg County, which I think helps with the mediator and helping the attorney to help the client understand what's the reality of going to court is going to look like.
Yeah, exactly.
So.
And I think on the note of, the attorney kind of getting in the way, I think most of us, at least in our office, don't have that mentality. We're there to do what our client needs us to do, what's best for that client. And oftentimes it is resolution in that moment. And I often find, I don't know if you find this as well, that sometimes mediation really early on in a case where it's not ready yet. The parties aren't ready yet to resolve anything. There's still a lot of emotion. There's still a lot of the idea of I need to fight and be mean, at least in my cases. And sometimes it takes us multiple rounds of mediation to get to a place where everybody, sometimes the lawyers and the parties, but hopefully just the parties, are able to be reasonable or make compromises that they otherwise weren't able to make, months earlier.
Yep, absolutely. And I've spent a lot of time working with individuals in the profession who do high conflict, who deal with high emotions in cases. And I believe that you cannot resolve the legal issues until you have resolved the emotional issues. So yes, sometimes cases come to mediation too soon and we need to back off. But I think I'm a pretty good judge of that. And when I see that happening and I try to work and empathize and try to get through what's really hurting the person so that we can move past that. If I have an attorney that's not at that same spot, I will adjourn the mediation and just say, look, I think we need a pause. Here's what I think needs to happen. And sometimes that's a conversation with the attorneys outside of the room. Your clients just aren't ready, right? We'll get this resolved, but we've got to get them past the emotion that are happening so that we can then focus on the legal issues. If you focus on the legal issues first and you don't resolve the emotions, chances are your client's going to end up hating you as the attorney, right?
That's
because
true.
you're not going to get a result that they were anticipating.
Exactly. I try not to be hated by my clients.
I know, me too. Me too.
And that's a good point too of what it's like in mediation. I think sometimes people come with this idea that you're going to be forced to sit all in the same room together, and that's not the case. It's meant to be you're apart. You're not staring at the other person the entire day or being forced to sit in the room with, your ex-spouse the entire day. So can you talk more about your process there and how you ensure people are comfortable and can use their rational minds as much as possible?
Yeah, absolutely. So what I typically do is when people come in for mediation, I get them out of the lobby first so that because I don't know the case at all. I don't know what the dynamics have been. So I try and get them out of the lobby first so that they don't run into each other and we have, a brouhaha in the lobby. So I do that. But then I go in and I talk to whomever's come in first and then the other person and just sort of gauge how I can sense that they're feeling about all of this. And I will ask the client, not the attorney, do you think you want a joint session so that I can go over all the administrative stuff at one time? And as a mediator, I ask that question because for me, it is sometimes important to see how the two of them interact in the same room if I can get them in the same room.
Yeah.
After I go through the administrative stuff, if everybody's getting along, I may ask the question, do we want to all stay together and try and resolve some of this? Typically, the answer is no, put us in separate rooms, which is what I do. Rarely have I had a case, maybe 2 or 3 in my career, where they've actually been able to resolve things in the same room. It doesn't happen very often. But it is important, I think, for the clients to make that decision and not for me or for the attorneys to make that decision so that they feel like they're invested in the process from the beginning.
Yeah.
And then what happens is you're in separate rooms with your attorney. You're free to move around. I just ask people to make sure the attorney has a way to get in touch with them so that if they need a break, need to walk around outside or do something else, they can do that. And then as the mediator, I just go back and forth between the rooms, taking offers, questions, back and forth as well.
And so once that joint session is done, if it is done jointly, then the parties will not see each other for the rest of the day.
No, not unless they run into each other, going to the bathroom or something like that. They will not. Mm-mm.
And usually you try to get one party out the door first and then the other one out the door afterwards so there isn't, a brouhaha in the parking lot.
Yeah, if it's a contentious mediation, absolutely we'll do that.
Yeah.
And I've had a few. I've also had some where there's been domestic violence protective orders that have been in place and I'm not told. And those can be really, really difficult because it's a violation of the order if they're in the same space. But we usually can work through that in some way.
Yeah. And that's a good segue to what is it like to have attorney-led mediation where the parties have lawyers who are guiding them versus not? And would you suggest mediating before you have lawyers for those who are watching this who haven't yet hired a lawyer?
So when lawyers are in the room with their clients, I make sure I advise the client, this is your mediation. These are your decisions. Yes, your attorney is here to help you. And yes, there are other people, myself included, that can help guide the process. But at the end of the day, it's your decision. So if at any point you and your attorney are in conflict with something that we want to have done, then I can step out of the room and you and your attorney can have a conversation about that and determine where our next steps are. But at the end of the day, if I have an overbearing attorney that's just balls in, I'm not going to let my client talk, I typically will take them out of the room and say, look, what are we doing? This is not your mediation. Your client has to live with this for the rest of your life. You'll be able to close this and move on to your next client.
Has that ever happened with anybody in this office?
No, it's never happened with anybody in this office, but there are some litigation, some strong litigation firms and some strong personalities out there where attorneys really believe that they need to get their peacock feathers up, if you will, and really show their client that they're in charge of this process. And that's really not what this process is, which I think is an educational issue that we've not done a good job with explaining to some of the newer attorneys. This isn't law school. This isn't litigation. This is mediation for a reason. And it's a mediation to save your client money and time to try and get this resolved. And it's probably been court ordered, right?
Sure.
So you're here anyway, so might as well make good use of it.
Do you think that the clients that come that have attorneys at mediation have a higher success rate of resolution?
I think that for me in my mediation practice, I resolve most of my mediations, whether there are attorneys or not.
Well, that's such a testament to you as a mediator. That's amazing.
Well, I don't know if it's a testament to me, but I truly am a problem solver. I have been. I never think of litigation first, have never thought about litigation, but I always think about, okay, how can we resolve what's happening here? And so for me, most of them get resolved, whether there's attorneys or not. And I know those attorneys in town that I may get appointed to help that are just coming to check the box. And for those, I may not push as hard because I know that that's not why they're there.
Sure.
And I hate it because it hurts the client and the family, and it's just more money that they're spending. But there's sometimes nothing I can do about that.
Sure. Well, I think on my end of this, I certainly try not to be the lawyer with the peacock feathers. I like to passionately argue and zealously advocate, but also very much agree. And I think most of us, certainly in this office and in our community, understand that when we're in mediation, we are really trying to make a good faith effort to help resolve the problems in a way that achieve our clients' goals and as many of their priorities as we can possibly get.
Yeah, and that's perfect because that also tells me that you and all the other attorneys here, and myself included, when I have clients, we prepare.
That's right.
So
Yes.
we're prepared. We've already set those expectations with our clients so that they're not coming into mediation with unreasonable expectations. There's charts that can be completed ahead of time. There's discussions that can happen ahead of time. There's a first proposal that can happen. If you're a great attorney, you're already talking to your client about, okay, what's your best result and what's your worst result?
Yes.
So that I can work as the mediator to try and bridge that gap.
That's exactly right. And that's such a great point. That's exactly what I do, and every lawyer in this office does. I prep extensively for mediation. I have a multi-hour meeting with my client before mediation, and I try to do that, many days before mediation so the information can sink and, ruminate. But yes, I prepare my equitable distribution asset debt spreadsheet charts. I create options for support. I create options for custody arrangements, talk through all of that, come up with my client's best day, the worst day, some of the middle ground, and come up with that first offer based on all of that, and absolutely try to temper my client's expectations and prepare them for that compromise. One of the things I always tell my clients is around the 2 p.m. mark, because mediation is usually a full day. Around that 2 p.m. mark, you're tired, you're mad at me, you are going to say the other person is, running over us and getting everything. And that's because you have made compromises and it doesn't feel great. But the other person in the other room is saying the exact same thing to their lawyer because they're being forced to compromise. And it's a hard thing to do, just human nature, But I tell my client that every time. And sure enough, most of the time in mediation, unless I have a very cool client, which sometimes happens, they're, emotional about that 2 to 3 p.m. mark. And I say, hey, remember how I told you this is going to happen? And sure enough, here we are.
Yeah.
But it means it's working. And they're making those compromises and getting to a place that feels okay. Doesn't feel great. Doesn't feel bad. Feels okay.
Feels okay. That's right. And I support those attorneys that tell their clients that, because I also reiterate it. It's like, at some point today, you're going to think we're not making any progress. And I'm also going to hear that from the other side. But remember, you're not in the other room. I am.
Yeah.
So I will continue to keep moving in the right direction if I think we're making progress. But if I don't, I'm not going to keep you here unnecessarily. Sure. We'll let you go and we'll deal with it. But even if it's baby steps, yes. And you're going to feel terrible at some point during the day. I always try and feed everybody, or at least offer food so I don't have hangry people as well.
Hangry people at mediation is a terrible idea.
It's hard. Yes, it's absolutely hard. But the prep going in, I think some of the younger attorneys, not here at Marcellino Moore, but some of the other younger attorneys in Charlotte, they don't understand that the prep is not the mediator's responsibility.
Right.
The prep is the attorney's responsibility. Right. And you need to come to mediation with a level of preparedness so that you can resolve the case.
That's right.
And like you, it's not going to feel great. I tell people, if you can get to a result that you can put your head on the pillow at night and sleep, it's probably an okay result.
Correct.
And you should be not happy about it necessarily, but you should feel closing this chapter and moving on is as important as what you may have thought you gave up.
That's exactly right. So, and like you said, if you just can't get there that day and you reach an impasse, that's okay. And there is option for next steps, and maybe coming back to the mediation table down the road is a possibility.
Yeah, absolutely. I had one that I tell people every now and then. I had one. Both parties represented by attorneys. They had come from out of town. One of the guys left my office 6 times.
Oh, wow.
Sat in his car, and we just watched him from the window. And he eventually came back, and we eventually got the case settled.
Wow.
But 6 times, he's like, I'm done. I'm not doing this. I'm done. And we're like, okay, well, I'll impasse it. That's fine.
Yeah.
And then he came back.
I definitely had the people who have needed to take a lap around the building, and that's okay. I get it. If we're in our office, there's a really pretty neighborhood just like right there.
Yeah, exactly.
Yeah.
I've also had attorneys that have just jumped up and said, we're done. I'm like, you don't get to make that decision.
Right.
I've been court ordered by the judge, so I'm in charge.
Sit down.
So we're going to sit here until I say we're ready to go. But you, attorney, know that I'm not unreasonable, and I'm not going to keep you here if I don't need to.
Yeah.
But we're going to keep doing this. And that particular one, I remember that was, we got that one resolved too. So,
well,
I mean, they're just, everybody's emotional.
Yes.
Everybody wants to advocate for their client. I get all of that. But at the end of the day, we need to be smart about it as well. Interest-based negotiation is where I start. And most of my peeps that do mediation will start there as well. Attorneys want to start with a position.
Right.
I try not to do that. Like, what is important to you today? And Lynna Moen, before she left, she mediated one for me that I thought was going to go balls down. They're all going to spend every last cent of their money fighting because they just hate each other so much. And she got it done. But one thing she did at the very beginning that I really liked was, what do you want to have happen today?
I like that.
To the client. Just what do you want to have happen? And that gives the client the opportunity to say, this is what I'm scared about. So it's an indirect way of saying what's important to you, or what is the interest or the fear that you have, by just sitting back and just letting them talk.